Let's fill out the Kansas General Power of Attorney together, the document that lets someone you trust handle your money and property. Start with you, the principal. Type your full legal name and where you live. Use your full legal name exactly as it appears on your ID, so there's no doubt who signed. Now name your agent, the person you're giving authority to. Here, Ben Carter, with their address. And name an alternate. Here, Carlos Diaz, in case your first choice can't serve, so your document doesn't stall if something happens. Now the powers. The form lists subjects A through N. To give your agent authority over everything, initial the line in front of N. To grant only some, initial just those specific lines instead. Then choose when it takes effect. Here, effective immediately. One important thing, depending on your state, a general power of attorney may stop working if you become incapacitated. If you want it to keep working no matter what, ask about a durable power of attorney instead. Finally, print your name and date it. Sign it the way your state requires. We'll cover those exact rules in the recap. Then, give a copy to your agent and to anyone they'll deal with, like your bank. First, the power of attorney needs to be signed by the principal, and it must be dated and acknowledged in the manner prescribed by the revised Uniform Law on Notarial Acts. That acknowledgement piece is important, so don't skip it. Now, what if the principal can't sign it themselves? The power of attorney may actually be signed by an adult designee of the principal, but there are specific conditions. This has to happen in the presence of the principal, and it must be at the specific direction of the principal, expressed in the presence of a notary public. So the notary needs to be right there for that direction to count. Here's something that might surprise you. A power of attorney does not have to be recorded to be valid and binding, whether that's between the principal and the attorney in fact, or between the principal and third persons. So recording is not a requirement for validity. Now, if a triggering event or condition is relevant, any person to whom the writing is presented shall be entitled to rely on an affidavit executed by the attorney in fact, setting forth that such event has occurred or condition exists. Also keep in mind, an attorney in fact must have agreed expressly in writing to act for the principal in such circumstances. And finally, a power of attorney shall be deemed sufficient if it is in substantial compliance with the form set forth by the Judicial Council. Remember, this is general information, not legal or tax advice.